Well, Article 13 is back in the news, of course, and coinciding with a load of important votes in the UK on Brexit, which leads a lot of people to go, I told you so, in various ways, that the EU is some kind of despotic tyranny or something. Before I launch into this, Article 13, and to a lesser extent Article 11, are not good things. Neither was the Digital Millennium Copyright Act and similar issues that have occurred in the States and elsewhere. But it's not quite as bad as all the hyperbole would make it out to be. Now, I still think it should be stopped. I still think it should be blocked, and the opportunities to do that haven't all escaped us yet. But I think it's important always to argue from a position of knowledge and accuracy. First up, the deal still has to be passed by the European Council. The European Council is made up of the Presidency of the Council and the Commission and the elected heads of state of each member country. And there's also a possibility, if they don't block it, of an individual nation using its veto power to block the legislation in whole or in part. While Article 13 and to a lesser extent Article 11 are shit, they are not quite as shit as many people have been saying, and there could be upsides, especially for content creators such as musicians and videographers who've been slapped about a great deal by the internet overturning old and established models of communication and remuneration. You have to remember that, depending which country you're from, there hasn't necessarily been a case for fair use and so on in European nations. While the protections for that kind of speech in Article 13 and 11 don't go as far as they do in the United States, it does provide a baseline, and the language has been changed to allow parodic or snippet comments, transformative content. So your memes are not going to be taken away, your gifs are not going to be taken away. That's explicitly the case now. The rules in Article 13, which is now Article 17 by the way, the rules largely only apply to large services, YouTube, Facebook, Twitter, etc. And in some of those cases, whether it applies is pretty questionable as well. Smaller sites are not subject to the same rules or restrictions, and what counts as a good faith effort in the legislation is contextual. So a small company, the kind of effort, the kind of solutions that they're expected to come up with are not the same as those that a tech giant like YouTube or Facebook would be expected to come up with. So this could be good news for smaller, more agile competitors to the tech giants. The social media space in particular is really in need of a shake-up. We may also see some division come about in some of these larger sites as they split up into sub-companies to avoid the full extent of the law. For example, one possibility might be that YouTube splits into a commercial YouTube and a user content YouTube. Educational, scientific, non-profit and similar sites are all exempt from these rules as well, as are personal cloud services, open source software platforms, online marketplaces for the sale of content, resale of material and so forth. So if you take a photograph of something and put it on eBay that you own, you're not going to get in trouble there. The scope of the law is actually fairly narrow, and as I said before, mostly affects the tech giants, which is perhaps why they've been kicking up such a stink about it and trying to activate their user base. Even if people abuse services to upload material, it doesn't necessarily mean that the service gets in trouble, unless that's the main purpose of the site. And that would be something which would be arguable in court. So services such as Mega and so on could get into trouble, but then there would have to be a court case, and the court would have to establish the reason that the service works that it is for piracy. This will all have to be disentangled via legal cases, and that's another line upon which you can fight back potentially, backing, participating in, witnessing to, and so on, various legal cases, which will determine the actual bounds of the law, how it will be applied, will set precedent, what counts as a good faith effort, and so on. The law as it's written could be interpreted very tightly or very loosely, so judicial activism is another path to challenge the law. Sites are expected to make best efforts to remedy, which isn't too similar to the takedown notices that we're all already familiar with, and could end up being enforced in much the same way. YouTube, for all the problems that we have with it, is essentially already compliant under that interpretation. They check content for copyright breaches, they issue notices, they redirect money towards the people who've been wronged in whatever way. So YouTube's probably an example we're all familiar with, and one that is already probably 95 to 99% compliant already. Again, depending on the interpretation of the law, and with Google's pockets behind it, YouTube is in a position to challenge the law and get some rulings and try and feel out what it all actually means. What we may find is a more zealous degree of enforcement, and strikes being more common if we step out of line. While the legislation now makes allowances for a degree of fair use which wasn't necessarily enshrined in European law before now, snippets, parody and so on, it remains to be seen how that will be enforced. But that's already getting tighter. On YouTube, for example, you used to be able to use up to 20-second clips of music or video or whatever without running into any problems with copyright claims. That dropped to 15 seconds. It's recently dropped to 10 seconds, and sometimes even less than that will be detected. It would be good to have some kind of bounding where we can say that you can use, say, 10 seconds of a clip of music or video or whatever, with that being considered fair use, but we'll see. But at least now we're going to have some kind of fair use protection in EU law. Considerations are given to the type of site, the audience for the site, the size of the site, the service, the kind of works, the subject matter, and so on. They may not even be able to prosecute corporations from outside the EU, and that would create a call my bluff sort of situation. Would they block the sites within Europe? How? Companies with less than 10 million turnover are exempt, and there are similar kind of restrictions depending on traffic and so on. There's a 3-year exemption for new sites, and it'll take 2 years from whatever point this gets approved, if it does, for all nations to bring it into force. So there's time and opportunity to get some of those legal precedents and so on. On the plus side, it is intended to harmonise rules across Europe. So if you can access content in one European state, you should, after this, then be able to access it in every other, regardless. Now, it's not a good thing at all. The various other restrictions that have come in haven't been a good thing, and it should be resisted. But let's resist it on the basis of the actual text of the document and what it means. And if you want to resist it, petition your local governments, contact your local politicians, express your concern, ask them to vote against it in the council, and we'll see where it goes from here. After that, it'll be down to legal precedent, and that will probably come down to the big tech actors such as Facebook, Google, and so on. But let's argue from a position of accurate knowledge. Zang.